All right, let's be on the record in case number 2019-CR1415, captioned in State of Kansas versus Terrance Moore. Would the parties announce their appearances, please?
May it please the court, the state of Kansas appears virtually through Assistant District Attorney Adam Sokoloff.
And Mr. Moore appears in person through Counsel Mark Bostwick via Zoom video.
All right. We're here set down for a sentencing. Looks like back on August 3rd, the parties got together in a similar manner. And at that time, the defendant changed his plea from one of not guilty to guilty. The court inquired and accepted, ordered a pre-sentence investigation, and set it for sentencing today. I've received a copy of that pre-sentence investigation. The critical findings are as follows. The sole count of conviction is one of criminal threat, which is a severity level 9 person felony. The defendant's criminal history score was found to be that as of A as in Adam, which would leave him with a presumed sentence of prison, with that presumed range being 15, 16, or 17 months. If he has to do that time, he'll be eligible for 20% good time credit and subject to 12 months of post-release supervision duration. If he is granted probation today, it would be for a period of 12 months to community corrections. I would ask you, Mr. Sokoloff, did you have a chance to review the pre-sentence investigation? Do you have any additions, corrections, or challenges to those findings?
I did receive and review the document, and I have no commentary thereon.
All right. Mr. Bostwick, I'd ask you the same question.
We have no objections, additions to the criminal history.
All right. Mr. Moore, your lawyer tells me then that he's gone over this with you. You've looked through that criminal history report and you're not challenging it. Is that correct?
Yes.
All right, thank you. Mr. Bostwick, you did file a motion for a downward dispositional departure. I reviewed that motion. Would you like to be heard on it today?
Yes, I would, Judge. Mr. Moore, I believe, has several different substantial and compelling reasons for departure. First of all, this is a joint recommendation for probation. It is done both with the defense and the state. So there's no argument or opposition. That is a substantial and compelling reason for departure. He took full responsibility. He waived his constitutional rights, saved the county time and effort, and showed regret about the whole thing happening. That is a substantial and compelling reason for departure. Judge, noting that his person felonies are 10 years old, 29 years old, 30 years old, and there's 2 that are 32 years old. So he has not been in trouble for 10 years, and there is a substantial period of time between 2010 and the other person felony entry before that. I believe that is a substantial and compelling reason for departure. Mr. Moore is on, now I'm turning to number 6. Mr. Moore is been on disability for schizoaffective disorder and bipolar disorder. I believed at the time that this occurred that he lacked substantial capacity for judgment, and he was not on his meds. On top of that, his mother, who is now deceased, he is the caretaker for his mother. She was in a pretty precarious position over at KU Medical Center, at least in Mr. Moore's view. And I believe that that caused him considerable distress, mental anguish and distress. And I believe that is a substantial and compelling reason for departure.
All right. Mr. Sokoloff, any comment on Mr. Bostwick's motion?
I would say generally those were all of the factors that the state included when it sought to make this recommendation to the court. I will say, specifically, I believe it a relevant argument to the court that in some way mitigates his culpability. I will say that I'm not at any point going to agree that he lacked the capacity to form the intent for this crime. And I don't believe that is what Mr. Bostwick is suggesting, but
No,
rather
no.
his capacity was obviously diminished and affected by both the context of the situation, the traumatic emotional state he was in, and his battles with mental health. So all of those things considered, all of the things in his motion were what went into the state's agreement. And in the end, a year or so of prison is not what it's going to take to make this community feel comfortable with Mr. Moore. It's about him getting on the right track and getting resources and making healthy choices. And I don't think prison for 14 or 15 months or whatever it ends up being is our best tack. So we join in the recommendation for probation for Mr. Moore and hope that the resources that are out there will be to everyone's benefit.
All right. Okay. All right, Mr. Moore, you have the opportunity now to tell me anything you want me to know in mitigation of your sentence today.
I just wanted to say, I never had any intentions on going to do anything to anyone. It was in a very emotional time. I felt as though my mother was in a situation medically that she shouldn't have been in at KU, and they discharged my mom and sent her home with no instructions or medications, and she had to go back in the hospital for congestive heart failure. And so I never had any intentions on harming or hurting anyone. It's just a conversation we had, and I don't know what happened that day, and I just was totally upset at the way my mother's care was being carried out at KU Medical Center. And I had filed a complaint with Medicare, and from that point forward, everything went downhill with her health there. I've lost my mom. I've had my family life threatened and exposed because someone researched me and found out I had a case in Kansas, and with intentions on trying to harm me and my wife and kids. So I've been under a lot of stress from this case, and I've learned a lot. I am back on my medication, which has been hard for me to get since I've been living in Missouri because of the way it's designed here. But I've never had any intentions on doing anything to anyone. I have medical conditions of my own. I can't even walk upstairs without breathing heavy because of my heart condition and the stench that I have. And so I've never had any intentions on hurting anyone. It's just that I love my mama.
Yep.
And I said some things that I shouldn't have said, and that's why we're here today.
All right. Thank you, Mr. Moore. All right. Mr. Bostwick, do you know any legal reason why I should not now proceed to sentencing?
No, Judge.
All right. Well, I am going to grant the motion for the dispositional departure. I'm going to adopt this substantial and compelling reasons, all of those placed in the defendant's motion and mentioned today. I guess with the exception of that it's an agreement between the parties that there are substantial and compelling reasons is not in itself a substantial and compelling reason, but all of the other ones are more than sufficient to find that there does exist those circumstances that would make a dispositional departure just in this case. I do think that it is the product of many factors going on with the defendant and with his family. And I take him at his word, and I do believe that he didn't intend to actually carry out any of the harmful things that he had threatened to. And for all of the reasons, like I said, in the defendant's motion, I think it's appropriate to grant his motion for departure today. So given that, I am going to sentence the defendant to a period of 16 months in the Department of Corrections. If he has to do that time, he'll be eligible for 20% good time credit and subject to post-release supervision duration of 12 months. His application for probation today is considered and it is granted to community corrections for a period of 12 months. A specific requirement of that probation be that the defendant continue to comply with his mental health treatment and medication as recommended by doctors. I think that is the best way to make sure that this is the final time that Mr. Moore has to face these kind of things. All right, so when it comes to costs and fees, it appears that the defendant is suffering from a number of disabilities and is on assistance. Is that correct, Mr. Bostwick?
Yes.
All right. I'm going to waive his court costs, his supervision fee. I'm going to waive his attorney's fees in this case. I'm wondering though, is this the first Kansas felony conviction?
Yes.
It appears to be. His others were in other states. So I don't think that I have the ability to waive the DNA database fee. I believe that's a mandatory fee. So I think I have to assess that. But I can make Mr. Moore's payments, let's say $25 a month should be sufficient in the period of his probation to be able to get it paid off by that time. That's about the best I can do there.
Is that
So that will be,
$250?
pardon?
Is that $250 for that, Judge? I think it is.
Is it? I thought it was 400,
Well,
but I
that's
could be mistaking that for the drug fee.
yeah, that's the lab fee is 400. I think that fee is 250. Yeah.
Okay.
Sounds like $25 would be okay.
Yeah, I think that will get him done before his probation's up then.
And Your Honor, so forgive me, so I'm clear in filling out the journal entry. I heard you say that you were waiving attorney's fees. Are you also waiving the bid's application fee?
That is correct.
Thank you.
All right. So the only cost that he's going to incur is that DNA database fee. Everything else is waived. All right, Mr. Moore, you have 14 days from today to appeal anything you don't like about your sentence. You also may be able to seek expungement of this conviction after a period of time following successful completion of probation. As a convicted felon, it's prohibited for you to own or possess a firearm and certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. I won't go through the whole list, just suffice it to say, before you decide to own or possess any kind of weapons like that, talk to a good lawyer like Mr. Bostwick to make sure that it wouldn't be a reason to revoke a probation or add new charges, okay?
Okay.
And
There was not any kind of firearm. This isn't a registrable offense. Am I correct in that, Mr. Bostwick, Mr. Sokoloff?
I believe not.
Okay, so I don't need to advise him of that. Okay. Gentlemen, is there anything else for our record today that I failed to cover?
Judge, I would just request that the court allow Mr. Moore to interstate compact his probation. He is involved with a federal prosecutor in I don't know if it's a witness protection program. We expect him to be relocated, sometime in the near future. So they haven't determined where he's going to be located or as far as, so I would like to have him be able to interstate compact his probation to another jurisdiction.
All right. And the court, I think the court has the authority to block that, but it doesn't really have the authority to grant that. That's usually between community corrections. I am certain they won't have a problem. Usually, if there's a problem with an interstate compact request, it's the receiving state refusing, not us not. So that will be between he and his probation officer. Mr. Bostwick, the number over there at Community Corrections is 573-4180. If you or your client could contact them as soon as we're done, they will give him instructions on how to come in and go through his intake and start that process, okay?
Sure.
All right. Now, anything else that I failed to cover today?
Do we have anything else?
No, that's it.
Okay, Judge, thank you very much.
All right. Hearing nothing, we will be adjourned. Thank you all. Good luck to you, Mr. Moore.
Thank you.
Okay, thank you, Judge. You have a good weekend.
You do the same.
Thank you,
Okay,
Your Honor.
bye-bye.